Hello everyone. This video, actually I'm going to do a sequence of two videos regarding contracts. We're going to discuss contracts generally and then contracts that are common in the hospitality space. Contracts really are just legally enforceable promises. So go back to your days as a kid where you pinky swore and you said, you promise you'll do this, and you say, yeah, I do, and we pinky swear. Well, contracts are just a legally enforceable, more formalized version of that. It's just promises. That's all they really are. And saying that because I just want to demystify it. I don't want contracts to be as big and scary as they might sound. There needs to be two or more parties to a contract. So two or more parties making promises to each other. Specifically for hospitality, there are some contracts that are unique to hospitality that are in the PowerPoints that I uploaded for you that you can see, like management agreements, conference services agreements, events, banquet, those types of things where you have meetings coming into hotel spaces and they're booking the conference room. Similarly, weddings or other social events. And, obviously the big ones like at the convention center, those big conferences as well, those all have unique agreements and very specific provisions that are unique to those situations for hospitality. But hospitality also has like a number of other agreements that you're likely to see. You've got franchise agreements, which is not unique to hospitality, but it's extremely prevalent, particularly in the space of hotels and in food dining establishments. Think like McDonald's, Burger King. Similarly, you have the big hotel chains, and some of those are corporately owned, and then some of those are actually franchised out. So you have franchise agreements there. Real estate agreements, buying property, buying buildings to occupy for the businesses. Leases, those are common. Commercial leases, that would be the specific type of lease that we're talking about. Vendor contracts, you have in the space of events, you have rental companies, photographers, videographers, floral contracts. And then you also, in the space of more food and bev, have vendor contracts for who's providing your product. So let's say Cisco, US Foods, specialty produce, those types of things. Employment contracts, independent contractor agreements, and licensing agreements for intellectual property. So like if you were using someone's trademark and it's not your own trademark, but you're using someone else's, then you would have a licensing agreement giving you permission to use that trademark. So that's just contracts, generally just legally enforceable promises. Those are some specific types of contracts that you'll see in the hospitality industry. Your first assignment is asking you just that. Just list out however many, these 3 or 4, what the assignment says, types of contracts that you would see in hospitality. And if you're watching this video, you already have the answer to that. It's very simple. I don't need essays. You can literally just bullet point those out. And then, specific provisions that you might want in those types of contracts, whichever types of contracts you identify in your assignment. Think about some specific terms that you might want for your concept, the one that you created that you're working with now, that you used for the business entity project. What kind of provisions might you want in those contracts? And some sample ideas on provisions are also in the PowerPoints that I uploaded under Chapter 5 PowerPoint. So, okay, now I told you that contracts are legally enforceable promises, but in order for a contract to be legally enforceable, which means that a court can order a party to either perform on the contract or pay damages. And I'll talk more about what damages are in video 2. So in order for a contract to be legally enforceable, for a judge to be able to make a ruling and force a party to pay or perform, there are 3 elements that have to be present. First element is offer. There has to be an offer. The person making the offer is called the offeror and makes an offer which can be revoked at any time. And an offer is really just a proposal to perform an act or pay a certain amount of money with the intent to be legally bound to do so. So the offeror makes the offer to the offeree, and what that would look like would be something along the lines of me offering to sell my laptop for $1,000, let's just say. I offer to sell my laptop for $1,000. That's me making that offer to be legally bound, assuming someone accepts my offer. Now, if somebody doesn't accept my offer, I can revoke that offer and say, you know what, no, I changed my mind. I don't want to sell my computer after all. And especially don't want to sell it for $1,000, let's say. I can revoke that, or I can change it and say, you know what, actually, I didn't factor in like taxes and these kinds of things. It's new. Actually, I want $1,200 for it. And so I can say, you know what, no, it's not $1,000 anymore. It's $1,200, assuming that somebody has not accepted it yet. Okay. So as long as I'm still in the phase of just making the offer, I can change it or cancel it anytime I want. I have that power as the offeror. The offer also has to be made to an identifiable offeree. So I can't just throw it out into the world and say, hey, you could advertise. You can say, hey, this is what the current price is on this laptop. And you could advertise it, but it's not actually being made to someone specific. I'm talking in terms of where we would now be bound into a contract situation. So I would need to say, I offer to sell my laptop for $1,200 to this person specifically. I could, let's say when we're in the classroom, I usually can pick out a student and say, I offer to sell it to you for $1,200. That's a bona fide offer. That's legit. But if I just threw it out into the room and just said, I offer to sell my computer for $1,200. Well, how many of you are in this class watching this video? We have no idea who that specific offer is being made to, or who that offer is being made to specifically. So it doesn't constitute an offer in terms of what would be needed for a legally enforceable contract. However, if I said I offer to sell my laptop to the first student who responds to me and accepts my offer, now we have an identifiable offeree, meaning the person who's first to respond, which means now that that's been accepted, I'm on the hook to sell my computer for that. Now, here's the thing. Part one, I told you there's 3 elements that are needed for a legally enforceable contract. The first one being an offer, which I just explained. The second component that needs to be there, the second element, is acceptance. Somebody has to accept my offer. Well, the person, the offeree, who the offer is being made to, is the person who has to accept the offer. So the thing about that, though, is that it has to be accepted exactly the way I made it. It has to be accepted the $1,200 that I offered. I said, I'm going to sell my laptop to you for $1,200. You say, all right, I'll take it. I will take it at $1,200, no problem. But if you say, oof, I don't know, that's not brand new. You've been using it for a while. I'm not paying $1,200 for that thing. Maybe $1,000. I'd give you $1,000 for that. Well, that's not acceptance because it's not exactly the way I offered it. What that now becomes is a counter offer, and we start the process all over again. So you say, I'll give you $1,000, and now you've become the offeror and I've become the offeree, and I can accept your counter offer. And if I accept your counter offer, we've got a contract. So I said $1,200 because I knew no one's probably going to pay it. And if I said $1,000, I run the risk of somebody maybe coming back at $900. So I said, throw it out for $1,200. Somebody kicks back at $1,000. I'll take that. Now we have what's called a meeting of the minds, and we've hit elements 1 and 2, offer and acceptance. The third element in order for a contract to be legally enforceable is consideration. Consideration is the bargained for exchange. In this situation, we have money in exchange for a laptop. That's pretty simple. Oftentimes in hospitality, it'll be money for services. That's the bargain for exchange. Now, here's the thing that's interesting though about consideration, and this is just a fun like law school case I'm going to share with you, but consideration doesn't have to necessarily be money for services or money for goods or in exchange or services for services or money for money. Like obviously wouldn't do money for money unless different currency, I suppose. But anyway, let's say you did services for services or money for services, whatever. It doesn't have to be that. It can actually be what's called a legal detriment, which it can be a forbearance of doing something that you could otherwise lawfully do. So you forego doing something that you could legally do in exchange for services or goods or money. An example of this is an old case, goes way back, and it's called Hamer v. Sidway. That's the name of the case. And what it was is an uncle actually made a promise to his nephew and said, hey, look, if you don't drink, smoke, swear, or gamble until you turn 21, I'll give you $5,000. Nephew was like, all right, I'll take that deal. So we had the offer, right? We had I'll give you $5,000 if you don't do these things. And then we had the acceptance where the nephew said, okay, all right, I accept your offer. So now I offer an acceptance, but the thing that wasn't super clear was whether we actually had a bargained for exchange, because it wasn't the nephew giving the uncle something in exchange for that $5,000. It was literally the nephew just not doing something. And so what happened was the uncle ends up passing away. The nephew forgoes drinking, smoking, swearing, and gambling till he's 21. And he goes to collect on the deal, on his contract. And the executor of the estate didn't want to pay it, didn't want to pay the $5,000. So the executor is Sidway. So the Hamer v. Sidway is the name of the case. Hamer is the nephew, Sidway is the executor of the estate, and the uncle is William Story. So the court actually said that because the nephew was legally able to do all of those things, but chose not to do it and suffered what's considered a legal detriment, or with a forbearance of doing something he could lawfully do, that satisfied the requirement for consideration. So when the executor tried to say that the contract was not legally enforceable because it failed to have consideration, that the judge actually said, no, we're going to consider that consideration, a forbearance of doing something that you were lawfully able to do. And so they started coining this term legal detriment. And that is enough to constitute consideration. So those are the three elements that you have to have in order for a contract to be legally enforceable. I just gave you an example of how that gets challenged in court. It's not often that you see offer and acceptance challenged in court. If let's say somebody brings a breach of contract claim, one of the first things that the counsel on the other side might try and do is say, you know what, we don't even have a legally enforceable contract, so you can't sue for a contract breach because it fails for usually consideration. You don't see that often, but you will if you do see it. It's usually for failure of consideration. Okay, so those are the three elements that you need for a legally enforceable contract. And then one other thing I want to touch on in this first video is the UCC, which is the Uniform Commercial Code, which is a statute that was created to govern the sale of goods. So contracts that are for the sale of goods from someone or some entity that constitutes as a merchant is controlled or governed by the UCC. And what the UCC does is it actually puts in place these things called the implied warranty of merchantability, the implied warranty of fitness for a particular purpose, and a few others. So that the implied warranty of merchantability means that merchants can't sell defective goods. So whatever's being sold by these merchants has to be able to be sold. So it has to be what's called merchantable. So it can't be defective. And then the big one that we also see in hospitality is the implied warranty for fitness for a particular purpose. And what's interesting is, just as an example of how these got played out in court in hospitality, is if you know anything about the famous McDonald's hot coffee case, if you don't look it up, you can literally do a Google search for McDonald's hot coffee case and you'll find it. And I'll use this as an example on a few other things. But two of the causes of action that were brought, basically a woman got severely burned from hot coffee that she received from McDonald's. Two of the causes of action that were named in the complaint were breach of the implied warranty of merchantability and breach of the implied warranty for fitness for a particular purpose, because the argument was made that coffee at that temperature is not merchantable. It's basically defective. And then the implied warranty of fitness for a particular purpose, in this case, that purpose is consumption. And it is nearly impossible to consume coffee at that particular temperature that it was at. So those were the two causes of action that were brought in. So interestingly enough, it's not just like negligence claims that were brought in that hot coffee spillage case. There are actually contract-based causes of action that were brought in that case as well. All right, I will see you guys in video 2 for the rest of contracts described.